Hey guys, it's Kathy. I hope you had a good Monday. I had a good Monday. Lots of court today. Oh, yep, we're going to Florida, California, Wisconsin, Colorado, and Indiana today. Yes, we are. And it just happened like that. It was just an accident, but it was a good accident. Um, I don't know. There's one I'm gonna have to. Okay, is it the first one? Yes. So the first one I gotta explain just a little bit before we start. The lady who stands beside him in a little bit with the long blonde hair is not the prosecutor. She's the defender. You're not going to know that. That is absolutely not apparent at all. Let's go to Florida. Let's just go. Two cases here.
Next is 24 MM 401-678, State versus John Daly. And Mr. Daly, you qualify for the Public Defender's Office, so I'm going to appoint them to represent you in this case.
Yeah, I need spoke with
Just to make a statement.
That's the public defender.
okay.
So having appointed the Public Defender's Office to represent you, Mr. Daly, you've been charged with trespass on property after warning. And I do find that there is probable cause for that charge and set bond in the amount of $500 with special conditions that you're not to return to the location at 455 North Garland Avenue, the Link Central Station, downtown Orlando, as you're trespassed from that location. I also show the defendant was out on ROR in case number 2024 MO 400249. And having found probable cause that the defendant was arrested for a new offense, I'm going to revoke ROR in 2024 MO 400249 and set the defendant at no bond.
What is it? New case? Okay. I have no new case, old case. I'm not guilty, sir.
Nobody's guilty.
The next case is 24 MN 401685.
The judge ignored him.
Dewan Meadows.
So you're gonna need to know that she's the defender in the next one because it's so funny. Now I tried to add captions because I know yesterday people really struggled to hear Florida. Um, Florida's just a hard courtroom to get audio for. You're not going to be able to hear everything he says, but trust me, you hear enough.
The defendant posted bond.
And this guy still isn't leaving. She can't get him to go because he's not guilty. So he's just standing there.
24 MM 401690. State versus Trina Ruberg.
There, the other guard got him.
Next, I have 2024 MM 401691. State versus Devontae Young. All right. And Mr. Young, you do qualify for the Public Defender's Office, so I'll appoint them to represent you in this case. You actually have two cases that we're here on, but I'm going to address the arrest first. So in 2024 MM 401691, you're charged with resisting an officer without violence and possession of cannabis less than 20 grams. I do find there's probable cause for each of those charges. And it's to count one, the resisting without violence, set bond at $500. Then on count two, possession of cannabis, bond will also be set at $500 with special conditions that you're not to consume or possess any illegal narcotics or prescription medication without a valid prescription.
Sir.
The other matter, when you were picked up, there was indication that you were on probation. And so there's been a violation of probation that's charged. That's out of Indian River County.
So excuse me, sir, I don't understand why I'm getting charged for that down here.
So well,
I can explain it.
okay.
So you pick up new charges that violates your probation. You're not going to fight it here, sir. understand, you're gonna be transported to that county, okay? You're not gonna fight it here. Okay, so that's neither here nor there right now. All that the judge is doing is.
Yeah, that's what I was.
And
So the long and short of it is, Mr. Young, you're going to be. I've given you bond in your new cases, but on the VOP, you're being held no bond, and so should the new charges be resolved, then you'll be transported to Indian River County. They'll arrange for your transport to handle the violation of probation. Okay.
Speak to the judge.
I'm not the judge handling.
recorded, you don't like the answer.
I'm willing to resolve this Orlando case right now.
That's not how it
Whatever
works.
y'all give me, so I can go.
That's not what
That's
that's
not
not
how
what
it
we're
works.
doing today.
You're not gonna go anywhere, Mr. Young. You're not gonna bond out. Yes, you'll go back to Indian River. Your Honor.
That was awesome. You're not going anywhere. She's his lawyer. That's like me yelling at a customer when they're leaving the restaurant, and you're not getting any extra ranch either. Oh, I thought that was hilarious. That guy, it's just not going his way. Okay, now for this next one, it's a little loud, so I'm gonna turn this down real quick so I don't blow your ears out, and then I'll turn it back up if I have to, but I won't know because I'm not listening to my own stream. So we're just gonna go with it. Oh, it's still loud.
Yes. This is case 23, FB 013214, on for return on a bench warrant from settlement conference. Public defender is appointed.
Thank you, Your Honor. Stacey Johnson accepting the appointment. Is the court going to allow us to proceed with just making an next court date request at this point based on a 3-court meeting?
I want to have a little bit of information. Ms. Lopez, and I appreciate the fact that you've come back to court. The court's concern here, Ms. Can you move just the court's concern here is, were you released by the sheriffs this morning?
Well, I had the times mixed up. So
You were out in custody, you came back in custody.
well, they on record they said I had a felony warrant. So they put me in handcuffs and yeah.
So here's my concern. You have failed pretrial release on 2 occasions. Well, it speaks well for you that you came into court here today. I have 2 prior occasions in which you were released on pretrial and failed to comply or failed to come to court in some terms and conditions. At this point, the court is not confident that you would return to court based on any conditions that the court would place you under.
Your Honor, if I may.
Yes.
Ms. Lopez was originally released on pretrial level 5 with the next court date. She missed that court date, and last week she contacted me as well as Mr. Plummer in our office. Obviously I saw this for what it was with the pretrial situation, and I was trying to sort it out with other supervisors in my office. In the meantime, Mr. Plummer scheduled Ms. Lopez with a court date of today, I think without realizing any of the potential consequences of the pretrial situation. He also asked to recall the warrant based on her contacting us for the last couple of weeks. And I don't believe that this court nor the home court would have done that. And that's why I was trying to sort it out on her behalf. Ultimately, she was re-released, I guess, in February on pre-arraignment level 5. No fault of hers. She was given a court date of the same day on February 14th. She's indicated to me at least last week that she was homeless. She didn't have a phone. She's kind of had a lot of other things going on, which I understand that obviously the case needs to be prioritized as well, but her living situation has been her top priority at this point.
Did she ever check in with pretrial services?
That I cannot necessarily confirm. I don't know.
Can we find out if she ever checked in?
I'm not sure if the failures were just based on the missing the court date or what, but nonetheless, she had been given a court date the same day. At this point, she was in contact with our office. Whether or not we would have scheduled her for court, that warrant, I imagine, would have remained by Your Honor or Judge Franklin until she showed up in court. She assumed she had court this morning based on her communications with Mr. Plummer. She showed up this morning, was remanded, and then released on her own recognizance. She is here today. Based on my communications with her last week and briefly today, I do think she's in a better position now to try to sort this out going forward, checking in with pretrial.
I think here's where my my position's gonna be in this circumstance. If she complied with pretrial and just didn't show up to court, then I will reinstate pretrial in this circumstance. If she did not check in with pretrial or comply with pretrial as she was ordered to do, then at that point, I don't see keeping her out of custody. Does that make sense, Mr. Jackson? I understand, Ms. Lopez, the circumstances of your living situation, but when you're placed on those conditions are placed and you consent and agree that you're going to follow them. And they have to have some meaning beyond just it. And so, but I'm going to see whether or not you've checked in with pretrial services. And if you did, then I'll put you back on pretrial. If you didn't, then there's an issue for me with regards to that, because then you weren't complying with pretrial anyways. Okay. So let's see if you were otherwise in compliance.
She was first released on, I believe, back in September. Obviously, I don't know whether or not she had immediately contacted them when she was pre-arraignment released in February. But
why don't we do this while we're finding that information out? Ms. Lopez, I'm going to order that you not leave the courtroom at this point in time. You're going to be ordered to stay here. When we have further information, we're ready to recall it, we'll call it, but that way, pretrial is looking it up right now. Rather than installing the rest of the calendar, I'm going to go ahead and pass this matter for a moment, but do not leave the courtroom. Okay.
So she does take other matters while she's waiting, and I'm going to show one of them. But remember the other day when I didn't want to record this one court because the walls were too dark? Well, this one has a freaking cage right in the middle of it. I don't even think there's any chairs in that freaking cage. Hi, Lucy. So you have to contrast what happens with this case with what's going on with the one we just half watched. So that's why I left it in.
That's on page 35 more.
Yeah. Sierra Barbara Moore, is that your true and correct name?
Yes, ma'am.
This is case 24 FE 004080. Offense state February 19th, 2024. Count 1 alleges assault with a deadly weapon or instrument in violation of Penal Code 245A1. Count 2 battery against a person causing bodily injury in violation of Penal Code 243D. Count 3 alleges vandalism in violation of Penal Code 594. Public defender is appointed.
Thank you, Your Honor. Warren Wood with the Public Defender's Office on accept appointment, waive formal arraignment, further advisement of rights. Mainly that request the court to release Ms. Moore on the problem level 5. I've discussed that she will be required to stay away from victims in this matter, and that she will be required to take some anger management classes, and she's agreeable.
Your Honor, the people are opposed to release in this case. The defendant assaulted 2 different victims, causing injuries. The first victim was hit multiple times in the head with a metal crowbar and suffered a fracture to their skull, an orbital fracture, a fracture to their wrist, finger, as well as other lacerations to their head and hand. The second victim in this case was kicked 26 times in the face. Punched 26 times in the face.
Okay, how do they know that? How do they know she was punched exactly 26 times? The only thing that I can guess is instead of stopping the fight, someone was recording it for YouTube or something, and that's how they counted. But how did they know it was 26 times? Someone tell me.
Then the defendant pulled that victim's hair and kicked that victim in the face. I don't have injuries at the moment for that second victim. But in light of these acts of violence, plus her prior record of violence, she has 4 prior cases that were assault cases. One of them ended in a deferred entry of judgment, but the other 3 resulted in misdemeanor convictions in 2016 and 2018. So based on that pattern of violence and severe injuries in this case, I am opposed to her being released.
Ms. Moore, I will tell you, this is a very, very close call for me. In large part, looking at your record, there's a significant history of prior assaultive behavior. Yes, ma'am. That counted against you in terms of what the court was going to do. However, I believe that if you comply with the conditions that I have put in place, that we could be successful in terms of your release. So, as a result, if you comply with the following conditions, that you check in with pretrial services, 2 check-in phone calls per month, in addition to court date reminders, that you provide your current address and phone number to pretrial services, that you report any change of address, phone, or employment status to pretrial services immediately. It's your responsibility to make sure that pretrial services knows how to get a hold of you. Yes, you're required to obey all laws. You'll be subject to search and seizure of your person, your residence, and your vehicle by any peace officer without a warrant. Also, you are to have no direct or indirect contact with the identified persons listed, except in compliance with any court order. No contact includes, but is not limited to, any of the following: no texts, no phone calls, no online messaging, or written contact with the protected persons. In this case, Destiny, Destiny, Ramos, Ramos, and Samantha, Samantha, Conway, Conway. You are also ordered to complete 12 anger management meetings. I don't expect that you're going to have them done before your next court date, but I expect you to have a significant amount of them done before your next court date.
All they will.
Ms. Moore, take the anger management courses through Logan court classes online. I believe they're the least expensive available.
That's fine. She can take them through the Logan.
Thank you, Your Honor.
And your next court date will be?
April 3rd, 8:30, Department 61.
April 3rd, 8:30, Department 61. That'll be the order.
Thanks.
We can proceed with Lopez.
Recalling page 24, Raquel Lopez.
All right, returning to the Lopez case, do we know whether he or she checked in with pretrial services?
Your Honor, she was released pretrial arraignment on the 26th of February, and she failed to report on the 27th of February, and apparently the last release on March 6th was an OR.
Your
She
Honor,
has never reported to us.
she was pre-arraigned on February 14th. And before that, she was,
Does she do you have any notes of her having reported after February 14th, on February 14th?
or prior to that, when she was originally released.
She was originally released to us level 4 on September 1st. She did not report, and on the 27th, the trial was closed and the warrant was issued. Then on the 26th, it showed that she was PAR, and it was approved, and on the 27th of February, subject FDA.
Do you have her last, so she, I'm just looking at the screen real quick. It looks like she, on February 26th, she was given pre-arraignment in 4 o'clock calendar. On February 27th, she failed to appear here in this department, according to the court list. Motion to recall the warrant was on March 6th, which I signed because I did look at that. My issue ultimately is it sounds like this defendant has never checked in with pretrial services in either of the opportunities that she was given. At this point in time, I'm going to remand Ms. Lopez for failing to comply with pretrial services.
She's going to be clear. Do you have anything you need to give to him?
As soon as they get done talking, I'm going to thank you. Yes, it's going to be no bail, no 53.6. I appreciate the fact that you came in today, Ms. Lopez. The concern that the court has, if this had been the first time you failed pretrial services, I would have allowed it, but this isn't the first time. This is actually the second time, and you've never checked in. And so, unfortunately, your ability, the court has no confidence that if placed back on that program that you would check in, as you haven't done so at any point in time that you were required to do so.
Your Honor,
Can you tell me that this is my first time?
So I'm gonna return her. No bail, no warrant, no 3.6. I understand that she was OR'd in this case, but I believe that did not take into consideration the fact that she had failed pretrial services twice.
and Your Honor, she just wants the court to be aware that this was her first time ever dealing with pre-arraignment, pretrial release, or pretrial release at all. And as I previously indicated, she was homeless. She did not have a phone.
I understand that, but here's the situation. It's not your first time being granted it. You were granted it twice in this case, which means that you had two different judicial officers explain to you what you needed to do, and you agreed both times to do it. And you did not do so. You have, as a result of that, the court doesn't feel that you never checked in. And so that's the reason I looked. You know what? This isn't, you don't get 3 chances at pretrial services. You were getting more than most people get by getting 2.
Your Honor, can we have March 18th, 8:30, Department 62, notice of bail motion?
March 18th, 8:30, 62, that'll be the order.
So she was homeless, didn't have a phone, missed pretrial twice. So, okay, I get that. You know, but that other lady punched someone in the face 26 times and hit someone with a crowbar and then kicked them, and she gets an OR bond. I don't know. I just know that nobody liked this courtroom, man. Whoo! Viewers dropped off like flies. I have to try to fix it because, hi Kelly, I have a lot of people who live in California who watch this stream, and Sacramento is the only court that I can find unless I go to like the Supreme Court, and I can't do Supreme Court cases. Well, I don't want to because they're real long, a lot of lawyer talk, it gets a little boring, and there's no verdict. So you have to wait like 2 weeks until they provide a written verdict, and that's so much work. There's no giggling. Never. It's just all lawyer stuff. So I'm going to have to figure out a way to make this Sacramento courtroom work. I'll fix the audio. I'll do my best. I did it with Florida. See, that Florida audio was pretty good today, not like yesterday. This one's only a few seconds long, this next one, but we're going to go to Wisconsin just for a few seconds. Even though there's a lot of cheese there. But we can't stay.
Your Honor, we're joining in this recommendation. It wasn't really bad driving. He was driving at night without lights on, but it was in town, so it was with the street lights on, and it was hard to tell.
I think that the public defender should say that out loud again real slowly, just so she understands that that's probably not good. This guy was driving around town with no lights on. So she's like, it's okay. It was in town, you know, where all the people live, so it doesn't matter. Yep. Yeah, that was her defense, guys. He didn't win. The rest of it was boring, but no, he didn't win. Oh, your home has been purged and you cleaned it out, Kelly? Man, I wish I could do that. That's awesome. That's amazing. All right, guys, we're going to go to Colorado, and I'll turn the volume back up once it starts.
Jail, what was your name? I know I muted you a minute ago.
There, is the volume good now?
William Richards. Okay. It says 54 DO2 2402 CM 461 State v. William Richards. And I've got a mailing address for you. Is that a good mailing address for you?
Yes, Your Honor.
And what's a good phone number? And do you have an email address?
Yes, sir. It's Lee.
Okay. And let's see. You've been charged with 2 counts. Count 1's invasion of privacy is a Class A misdemeanor. State alleges that on about February 5th of 2024 in Montgomery County, state of Indiana, you did knowingly violate an order issued under Indiana Code 353383.2 by the Circuit Court of Tippecanoe County under cause 79 CO1 2310 F5218 to protect Kimberly Marino, all of which is contrary to Indiana Code 3546 115.1A11 and against the peace and dignity of the state of Indiana. Class A misdemeanor carries with it a penalty from 0 to 365 days in the Montgomery County Jail and a fine of up to $5,000. Count 2 is possession of paraphernalia. As a Class C misdemeanor, state alleges in that same date, same place, you did knowingly or intentionally possess an instrument, device, or object, to wit, a glass pipe, that you intended to use for introducing into your body a controlled substance, all of which is contrary to Indiana Code 3548 8.3b1 and against the peace and dignity of the state of Indiana. Class C misdemeanor carries with it a penalty from 0 to 60 days in the Montgomery County Jail and a fine of up to $500. Do you understand the allegations against you and the possible penalties?
I do, Your Honor. Yes, sir.
And you have certain constitutional rights. You have the right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves your guilt beyond a reasonable doubt. You have the right to confront and cross-examine any witnesses against you. You have the right to have witnesses come into court testify on your behalf. You have the right against self-incrimination, also known as the right to remain silent. And you have the right to appeal your conviction if found guilty. Do you understand you have all those rights?
Yes, Your Honor.
You also have the right to be represented by an attorney. And if you cannot afford one, the court can consider appointing one for you. Do you plan on hiring an attorney?
I do have a job waiting for me when I get out of here. I was incarcerated when the court date was issued, and also I was incarcerated in Tippecanoe County during the court date. That's the only reason I missed it. I have a job at McDonald's out in Miami County on my farm where I live. I've just been waiting. I got time served in Tippecanoe County, and I was unaware I even had a court date here. But I would wish to get a public defender because I do pay a lot of child support.
Okay, and I'm looking at the history. It's not, you didn't miss a court date. The court found probable cause and issued a warrant. It wasn't for failure to appear at anything.
Okay, given
your incarceration, I am going to find you qualify for a public defender. I'm going to enter a plea of not guilty on your behalf. We're going to set this for a pretrial conference April 2nd at 2 p.m.
Okay.
I'm going to leave bond set in the amount of $1,000. But that's something you can talk to your attorney about. So that should be.
So there's no way I could be released today unless I pay a bond.
Right. I'm going to keep that bond in place. Looking at the allegations here.
I wonder if there's anything he can say right now to change that judge's mind.
And also one more thing, Your Honor, the no contact order, I was never issued a no contact order to sign or anything. And it's actually, the state issued it because my wife actually tried to run me over. It was the other way around.
And I think that's a case pending in another court.
Yeah.
So I'm looking at the 79 CO1 2310 F5218.
And I was never issued it wasn't to protect Kimberly, it was to protect me.
I see that the cause cited. Give me just a moment.
That's why I was hoping to released today because I've only been in Indiana for a couple days, and I went to jail in Tippecanoe County.
Yeah, it looks like you're the protected person. Actually, yeah, I'm going to release you on your own recognizance today.
Thank you, Your Honor.
We're going to set that still April 2nd at 2 p.m. for
Yes, Your Honor.
trial.
I'm so glad I said something.
So that's, yeah, I'm not sure.
Yeah, I see. I didn't
They
know.
may have other interests there, but
Yeah.
you are not the defendant. You are the protected person
Your Honor.
in that case. So yeah, we're going to release you on your own recognizance. You do need to come back here April
Yes,
2nd at
absolutely.
2 p.m. If you're in another county, you can do that by Zoom. Just contact my court staff. They can give you that Zoom info.
Okay. Yeah.
And that's all for today.
Okay. Thank you, Your Honor.
Thank you.
I can't believe that worked. I mean, I'm glad it worked. If he's not the right person, I'm glad it worked, but I can't believe that worked. So, Whit, you're from Tippecanoe, Colorado, which, if there's people inside of it, it is probably a felony. Is that near Arapahoe? Which also sounds like a felony. Why do all of your cities sound like felonies? All right, now we're going to do one more. It's the end of a divorce with, two people that you know how it is in divorces. They don't get super bad though, just bad enough.
Medical condition that you have.
Yes,
Hi,
So
Cloud.
you think that you're capable of doing that?
yes.
And then the next question is, when can you make arrangements to get your items out of his house? And how much stuff are we talking about? We're talking about pickup.
It's quite a.
Let me talk to you first.
Apologize.
So are we talking about a pickup truckload or, renting a bigger vehicle, or is it stuff you can throw in the back seat of your car? What are we
No,
talking
I
about?
moved my whole house into his house. We got rid of everything that was in his house. Mine was nicer things, so I moved my whole house into his house. And now I don't have the room to put it back into my house because I let my daughter and my grandchildren move into the house. So she moved all her things in there, so my things would need to move into a storage unit or I have to sell it to him or make other arrangements.
If you were to make other arrangements for storing things in his house, how long would it take you to do that? When can you get those items out of the house?
Well, I would say, considering how much it costs to go into a storage unit in maybe 2 weeks.
So if we got this, if we ordered that she'd make arrangements to come pick up those things and move them to wherever she's gonna move them, within 30 days, would that be sufficient?
Yes, it would, but the situation is there's still stuff that hasn't been packed. I've been packing it, but I don't remember what all the small stuff. I've asked her, I've got 50 texts. Well, I've asked her both text one thing to come over, help me pack the rest of her little stuff up, get everything ready.
Okay, hold on. Is that something you think the two of you can do without a breach of the peace?
No, I would probably end up in jail with the way that
No.
he argues with me the whole time.
Is there somebody, do you have a mutual friend that owns a striped shirt and has a whistle that can play referee while you get that accomplished?
There would be no problem. The only problem right now is, Your Honor, is she keeps saying there's gonna be a problem, and there's no problem.
Well, if she's apprehensive about it,
Well, that's
I'm
fine.
going to accept that at face value for the moment, but I want to know, what do we need to do in order to overcome her concerns? And then you can demonstrate by your behavior that there's really no problem here. Is there somebody who could just kind of stand by and keep the two of you on track so that you get this accomplished?
I wouldn't have a problem having somebody there. But like I say, the thing I
Who do you
want,
suggest and who does she suggest? That's where we are next.
well, she'll probably bring her her sister's fine. She's done it before. It was the first time we were married. It's not the first time we were married. That's the problem. But I won't allow her daughter to come over here because her daughter is way outside the box, you know?
Okay, but that's why I'm asking this question, because there are people that if I were dealing with a difficult situation or one that I was concerned would be difficult, there are people who I think would be helpful to have there, and there are people that I think would just throw the whole thing into chaos.
Yeah.
And so if you don't want her daughter there, that's fine.
No,
How about your sister? Is she,
No, I have a friend, her name is Becky,
or your
Rebecca.
friend?
I think she would be better.
Oh my
And what
God,
is her
Becky.
name for the record?
Becky Ridenhour,
Do you know how to spell that last name? for the record?
Ridenhour, I believe.
I'm sorry, could you spell it one more time?
Ridenhour, Ridenhour.
Okay.
I think that's how it's spelled.
Okay, thank you.
That's close enough, at least, but all of them we're talking about. Is that somebody that would be?
I don't know who she is, but I don't have a problem with it as long as the person that comes over there is gonna be a calm and, you know, person that's not gonna start getting.
My expectation is everybody's gonna be calm, cool, and collected.
Right.
I just want to try to get it resolved. So
I just have
here's
one
what I'm
other.
going to ask you to do. I'm going to hold this decree under advisement. I'll enter an order today about the exchange of the property. I'll hold this under advisement until I hear back from you. If there are disputes, then what I would suggest you do is you start with the things you agree on and you keep kind of narrowing it down. And if there are matters about which there's some dispute, then rather than have a problem, when you get to the point where you have to agree to disagree, then you can come back to the court and I can try to solve those disputes for you. But start with the easy stuff. And if you get kind of at loggerheads with one another over some particular item, then move on to something else that you agree with, come back to that, see where we can get this worked out. Now, the other thing that I think often can happen on this kind of a situation is, said you have some question about where you're going to store all of these things. So this order would not prohibit you from horse trading. You could be in a situation here where you have something that maybe you aren't that attached to, and if you say, okay, I just leave this with you for X number of dollars, and if the two of you agree, just make a note of that, and then we would have that done. If you don't agree, that's another matter. You know, there are some things that well, I'll give you a perfect example. When I got divorced, I actually got along very well with my soon-to-be ex-wife. And we sat down at our kitchen table and I spent about 2 hours with her going through all of our stuff and dividing it all up. And we got down to the end and we decided two things. One was we had too much stuff because it took us so long to do it, even though we weren't disagreeing. And secondly, we had this couch, and we both agreed it was worthless, and we each wanted the other one to take it. This is a true story. So, neither one of us wanted this stupid couch. We just didn't want to be bothered by it. So, at that point, I reached an agreement with her. We would leave it at her house until the weather got a little bit better. And when she decided that she was ready to have it hauled out to the curb, I would come over and I would help haul it out to the curb so that it was done with. So we didn't want, neither of us wanted it. But that was a quick solution for us. And where we lived, if you put almost anything out on the curb, it disappeared sometimes within minutes, but certainly half a day was almost always gone. So we got it resolved. So that's what I'm suggesting to you.
They're not listening.
Pick the date while you're here. And then when you're there, start with the easy stuff. If you get stuck on something, move to something else easy, so that the amount of stuff that you're disagreeing about is shrinking as time goes by. And if there are a few items that are an issue at that point, then you can make note of that, request another hearing, and we'll sort it out for you. Will that work for both of you?
Yes and no. The problem I have is, okay, she has a lot of small stuff that needs to be packed up still. That's the problem. And I've asked her, that's why I asked her to come over and help me pack it up. And then we would make arrangements of a date that was good for her and good for me, for her to pick it up, because I told her I'm not gonna have a bunch of people in the house packing stuff up all over the place and moving it out at the same time.
Well, what I'm suggesting is that you get together and you agree on what's what. And if there are things if there's no disagreement about the stuff, and you take some of those things out with you as you go, and then pack up the other things in a range of time, that's fine.
And I don't have a problem with that. I've taken, all the clothes and makeup and all that stuff. I've already dropped it off at her house.
That's good, because you'd look pretty silly.
And every time I do, I get 25 texts because she's mad because I dropped it off.
Okay, but we're not here to prove why the two of you are getting divorced.
That's fine.
Hold on.
No, that's fine.
So the two of you still have enough problems communicating about these things that none of this is necessarily going to be easy. But we now have a path forward. You're going to find a time. You've got somebody to come and help you stay on point, somebody who can help you pack things up, bring lots of boxes.
I've got boxes.
You can't take all those things out at that point, then you set a specific time to do that. But you get things packed up as much as you can, and you get a date to do it. Yes, ma'am.
I wanted to go over and pack some things up and take a small U-Haul van and start by moving a little bit of things out at one time. If I'm gonna go in and pack it, I would like to be able to move it into the U-Haul and then transport it to where it was going. He says, no, I cannot do that.
Well, I think it's fine if you want to move it all at one time. But basically what that's still going to mean is you're going to have to go over and get it all kind of packed up and organized first. Exactly. And then
I cannot spend the day with him.
I'm sorry?
I cannot spend the day with him.
Well,
she wants me to leave my
other
house.
choice.
I'm not doing
My
it.
other choice is to just have all this stuff carted off to the auction and have it auctioned. And that's kind of a harsh.
And that's not what I want.
I think that's why we've got somebody else there. Yeah. The two of you strike me as people who still there's still some negative feelings there that are bothering, okay? But you also strike me as two people who can tough it out and get this thing done. So you're going to need to sit there, and you're more likely to be able to do that if you've got your friend there, because your friend can grab you by the sleeve and say, I think you need to sit over here and just take some time out.
Sounds like a felony.
You probably say to him in a way that you wouldn't be able to say to him, why don't you just give her a minute here? But I don't have the time to come over and sit there and wear my striped shirt and bring my whistle to get this thing done. And if you do this in court, and I have to hear testimony about what each thing is, what it's worth, and just dictate exactly how you're going to do this, you're both going to be unhappy with it. So find a time and get started on it. And understand that if you got a house full of stuff, it may not happen all in one day, but you may be able to to get some of the stuff moved and to get the rest of it staged so you can move it out efficiently. Yes, ma'am.
Some of it is very, very, very heavy.
Well, and that's why once you get to the big heavy items, then I don't intend any disrespect, but you don't want to look like the person I want to haul out my washer and dryer. You know, if I had somebody, I was gonna ask, which of the drums do I want to ask to help me move these things? I'd be asking your husband, not you, to do that. You don't look to me like a furniture room. So
Rude.
he understands, you're gonna have to have somebody come to do that. He just doesn't want to have a whole crew sitting there all day or in his house all day while this is happening. I get that, and that makes sense. So if you get all the smaller items packed up, you may be able to move some of those. And you know where the other things are, and then you've got the ability to rent the U-Haul and find the movers to help you do it. You know, friends or whoever it's going to be that's going to help you do that, and then you'll get it done. But you got to start someplace. In 2020, I moved out of a house I'd lived in for 37 years. It was not an easy task. It had a lot of rooms, a lot of furniture, and a lot of junk. And it was a major effort to move it. And that was with professional movers coming to help me do that.
Yeah, I was wondering about
So
that.
I get that this is not an easy task, but it's like how you eat an elephant. You know how you eat an elephant?
One bite at a time.
One bite at a time. So at least the point of this order is let's at least get the elephant on the grill or in the barbecue pit, you know, whatever we gotta do. But pick a date, and you may want to talk about 2 dates. One, to have you go over with your friend and try to get things packed up and organized, and then another date to come back with a moving group. But take a little time and do that right now.
When that's why I want to know when it's going to happen, because I've got to replace all this stuff, you know, the bed.
Unless you want to buy it.
So you've got.
If you want $400 for your carrier cabinet and the table you pay for it, I'll pay for it. I got no problem with that.
So again, I mean, you can have that discussion, but let's get the date set now. And the security people will get mad at me if I let you stay in here after 5.
No, yeah.
But here's the thing. I don't know, do we have another hearing after this one?
No.
So this is our last hearing. So you've got roughly 20 minutes here for you to have the opportunity to talk. So my order for today will show the cause came on for hearing, the parties appeared as unrepresented litigants. The parties that were instructed the court having heard testimony finds the contents of the petition are true and the same is to be granted, and the parties restored to the status of unmarried persons. The court finds that each party is responsible for paying any debts incurred in his or her separate name. The court further finds that the parties have already separated their motor vehicles and they have no joint debts or obligations that need to be addressed by this court. The court finds that the parties have reached a general agreement with respect to the division of property, but that they need additional time to make arrangements for personal property to be removed from the husband's home to the wife's home or to storage. Court orders the parties to confer to establish a date for the wife to help to sort and pack the items of personal property she is going to receive, and to make arrangements for her to come with individuals to assist her in moving the property. The wife may bring her friend, Ridenour, and Mr. First name.
Becky.
Becky.
Becky Ridenour. to assist her. Parties agree that the wife will not have her daughter assist her in. And then the last thing is, did you want a former name restored to you?
I had thought about it, but it's gonna cost too much and it was such a hassle to get it changed over the first time around. I don't know if it's worth it.
I don't have a problem with it keeping it.
Yeah, it doesn't cost anything to do that as far as the court's concerned here. Okay, hold on. It doesn't cost anything as far as adding it to the decree here. You just have the headaches of going to the license branch and vital records and so on, make those changes. So if you don't want to do it, he actually can't make you do that anyway.
Right.
But if I don't ask you that, we don't incorporate it in the decree, and then you decide you want to do a name change, then you have to pay a filing fee, and that's why I want to.
No, I changed everything over in Jerome, so I'm just gonna keep it.
All right, that should cover it. So I'm going to step off here, just let the two of you talk.
I needed to change your address for her mail, so it keeps, some of it keeps coming.
Yeah, you probably want to do that anyway to make sure that the post office starts forward. Okay, I'll let you talk about that, Dave.
Judge, do you want to set a deadline for the exchange of the table?
Let's order that the table be returned within 30 days of this date. Court recommends but does not order that the table be returned at the same time that the wife is moving out her larger items of personal property. That way you've got a truck.
Yeah, just bring a U-Haul.
What's that?
I can put it in the U-Haul.
Yes, right, that's what I'm thinking. Because if you're gonna have to have a bigger vehicle to move things anyway, you take the empty U-Haul to your house, you load up the table.
I can pick it up, I mean,
You bring it up. And you're always free to make other arrangements with respect to these things if you can agree. Okay? That will do it for today.
Okay, and then ma'am, are
So-
you still at 56579 County Road 3?
Yes.
And sir, are you at 28855 Melody Lane?
Yes.
Okay.
That was my
So
bad.
the divorce is final, right?
Yes.
We're done?
Yes.
Okay, just, I was gonna make sure of that.
I didn't know if the report.
Do you need to talk? You want to talk about it? Think you need to talk to us?
No, you can go ahead and work out a date if you want.
Right here, watch, hold on. Oh, never mind. Okay. There was a part where he was asking her if she wanted to talk to him. They just got divorced. She doesn't want nothing to do with him at all. Oh, man. So, who here thinks we're going to see them? One of them. I don't know which one. I think the ex-wife in court next week because of domestic violence. She's going to go over to pack up her stuff, and then she's going to get in an altercation. And then she's going to get in handcuffs. She told the judge that was what was going to happen. Aw, don't be grouchy. Yeah, wifey's going to snap. We're going to see her on an episode of Snapped someday. Do they still have that show on? Oh, well. That's all I have for today, because I have to get ready for court. And that could mean many things. I'm either going to jail or I'm going to go get some court cases. I got to pick a state. Someone give me a state, and I'll stick to that state. Oh, gosh. Guys, thank you so much for coming out. Thanks, Cloud. I hope you guys have a great day, and I will see you again very, very soon. See ya.